prayer when the matter is called. Ask someone to be here. You may not be there.
Lordship.
You understand you are not the counsel, but still it's 2021 matter of review. Ask someone to be here. Your junior may be here.
May please, Your Lordship. I beg to mention item number 6, my Lordship.
Item 6
6.
is 2019. Sorry.
May please, Your Lordship. Lordship, I beg to mention item number 55. Paying for an adjournment, my Lord. The conducting counsel is
35
session.
is read.
35, my Lord.
Okay. 35. Give a date after 2 weeks. Is date.
I'm obliged.
Okay.
May I please, Your Lordship. Lordship, I beg to mention item number 25. I am on behalf of LR Muzumdar, Lordship. And the adjourn for today, Lordship. Any maybe date may be fixed, Lordship.
Okay, this is motion matter.
Yes.
Okay. On the prayer made by learned counsel for the both sides are represented on the prayer made by learned counsel for the petitioner passed over for the day.
Obliged, Lordship.
May I please, Lordship? Lordship, I beg to mention item number 22. This may be
20,
22. This
22.
may be passed over for today only.
Same order. Okay.
Obliged.
Daily list item 1 for motion.
This implement order is page 41.
Sharma, this come for the first time after notice of motion. We'll take it in the admission column. Look. Records have come.
Yes.
Which was represented pursuant to order passed earlier. The records of the tribunal is received, which requires examination. Next, if you notice, returnable on so and so, list on so and so.
Lordship, as per the last order, it was supposed to be listed along with WBC 8921 of provision 19. Lordship.
Okay. And list on so and so, the admission column along with WBC 8921 of 2019. This matter in this 8921.
Yes, Lordship.
Has it
Expiry
been-
order was passed. Expiry order was passed.
No,
and
no,
in
has it been admitted for hearing?
Oh.
This is at what stage?
There is also notice was issued. Lordship, I will check in. Lordship.
Please check up whether, because if it,
Yes, yes.
because this case has been posted for admission. If that case is not ready for admission, then we can't keep it together. Just check up.
Lordship.
Any question of going through, you know? Just give a date. Yes, item 2. Item 2. Taking how the reporter say, same order here also. We are passing same order here also in item 2. This is for admission.
Item 3.
We are issuing notice and listing it for admission column. Same order in item 3 also. Item 3,
Item 3.
you're there. Okay, same order. For admission.
Item 4.
Okay, same order here also.
Item 5.
Same order here.
Lordship, can I go through the records once? Can I go through the TCR?
Yes, yes, definitely. TCR that. TCR to that. Item 6. Item 6. Non-application call for the question, how all the respondents are written. Same order.
Item 7.
the report. Same order here.
Item 8.
May I please, Lordship? In that case, if the similar order was passed, it was not admitted.
It's not admitted. Then you make a mention tomorrow and we'll get it listed.
Lordship,
In the meantime, we are fixing a date.
Lordship. Okay.
Or you can give the mention memo now also to the court master. Give professional. Give a mention memo.
Item 9 for motion.
Item 8.
Okay.
Item 8.
Yeah. You see, none of this. The notice, this one, transfer which.
Item 9.
None appears in call. Still notice. We are issuing notice in all these old matters.
Okay.
So wherever the TCS have come, we are fixing it for admission.
Item 10.
Absolutely. None appears. Notice list not concerned admission.
Item 11.
2019. Ascend, no? Okay, none appears. TCS is available. List of the admission. Item 12.
Item 12.
May I please, Your Lordship? Your Lordship, matter may be taken after some time, Lordship.
Okay. Cool. Notice registered admission performance. It's part.
Deeply observed.
Item 13.
So, ma'am.
Right to the notum. Oh. Okay, this is that exit permit.
Lordship, Lordship. Item 13 and 14, both are them.
Ah,
Lordship.
you got the information?
No, Lordship. Next, if possible, Lordship, next Monday.
Okay, CGC is available now. You're there, CGC. Do you have any information about the exit of this item number 13 and 14? Just get the information because they were foreigners. And because of passport, their conviction in Passport Act, they were behind the bars. But now their sentence is over, so they want to exit back out of the country. So they require an exit permit that was available. So the government of Assam would deliver them to Delhi so that they can go to their embassy and then travel back. Okay. 13 and 14 next Monday.
Next.
Okay. Please get this information, item 13 and 14, both. None appears on call. The Learned CGC as well as the Learned Standing Council for the FT and border matters. Pray for some time to obtain information regarding the regarding exit of the petitioners to their country of origin. List on Swenson. Yes, item 15.
Item 50, Your Honor, Mr. S.A. Ahmed is on the way coming, Your Honor. Can it be possible for the time being, Your Honor? Your Lordship. F2, it can be taken.
This is 2025. We are issuing notice. Mr. Sharma, we are
Notice,
issuing notice this 2025.
notice,
Your name?
My name is E. Ahmed. My name is not there here.
T. Ahmed.
E. Ahmed.
Mr. T. Ahmed, Learned Counsel appearing on behalf of the Learned Counsel for the petition on record. Also at so and so. Opinion at page 78 dated 27/11/2025, passed by so and so. Case number so and so, inquiry number so and so. Thereby declaring the petitioner to be a foreigner post 25 in 1971 stream. Notice extra copies within 2 days. All for the relevant records. Next, the prayer for bail is opposed by the Learned Standing Counsel for the FT and border matters, considering projection. 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police, Border, Sivsagar. List after 4 weeks.
Oblige, Your Honor.
But take steps to give them extra copies within 2 days.
Item 16.
May please, Your Lordship.
Opinion dated
Imperial order is at page number 50, Your Lordship.
58.
50, 50.
50.
Order dated 31/3/2026, Your Lordship.
26. Third. Mr. A. Rahman,
Yeah, Rahman.
Learned Counsel for the petitioner. Page 50. Case number so and so. IMDT number so and so. Declaring the petitioner to be a foreigner post 25 till 1971. Bail of rupees 5,000 to the satisfaction of Superintendent of Police, Border,
Borpeta.
Borpeta. List after 4 weeks.
Oblige.
Item 17.
Yes,
This is 22. Page none appears on call for the petitioner. All the respondents are represented. Opinion at page 29. Dated 19/11/2022, passed by so and so in case number so and so, reference number so and so, by which the petitioner was declared to be a foreigner post 25 in 1971 stream. In view of the inordinate delay in selling the imperial opinion, keeping the issue of maintainability open, issue notice returnable on. Give a date after 4 weeks, returnable on so and so. Extra copies within 2 days, call for the records. The prayer for bail shall be considered on receipt of the tribunal's records. In the meantime, if the petitioner, namely so and so, is apprehended, she shall not be deported out of the country without order of the court. However, petitioner shall produce a certified copy of the order before the Superintendent of Police. Cost production, before the Superintendent of Police, Border, Nagaon.
17th of August.
Yes, item 18. Non-appeasement call for the petitioner. Complaints are represented. Page 153, opinion dated 2011-2025, passed by so and so in case number so and so. Police reference number so and so, by which the petitioner was declared to be a foreigner post 25 to 1971 stream. Notice returnable in 4 weeks. Extra copies within 2 days. Call for the records. The prayer for bail is opposed by the learned standing counsel for the FT and border matters. Considering the projection, 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police, Border, City,
DCP board.
Gauhati. No, it will not be
DCP board.
Superintendent of Police, it will be Deputy Commissioner of Police, Border, City, Gauhati. So again, that authority is not a party here. I don't know. Notice that the concerned authority in charge of the foreigners matters in respect of district Kamrup Metro is the Deputy Commissioner of Police Border, Kamrup Metro Gauhati, comma, which has not been added as respondent number, respondent herein. So accordingly, the petitioner shall file an appropriate application for implementing the appropriate authority as one of the respondents in the matter. So this as and when the interrogatory application is filed.
Item 19.
May I please, Your Lordship? Lordship, in this case, the actual proceeding was in the name of some other person, my lord. But as the husband name is similar, my lord, the notice was served to this petitioner, my lord, and accordingly she appeared, filed her WS, evidences and all this, my lord. Thereafter, my lord, the learned tribunal came to the conclusion that, my lord,
Which
Lordship
page
may
is the
kindly,
opinion? Which page is the opinion?
Lordship may kindly peruse the impugned order.
Page.
Impugned order, my lord. That is page 93. And the relevant portion is at page, my lord, 97. Points for decision, my lord. May I submit, my lord? The actual reference was, my lord, the Jamuna Das, daughter of Santosh Das, my lord. And the petitioner herein is the Jamuna Das, daughter of Lalit Das, Lalit Mohan Das, my lord. And lordship will find that the learned court below, may I submit, my lord, at page 97, my lord, frame two issues, my lord. Issue number one, whether the opposite party, Srimati Jamuna Das, is the daughter of Lalit Das, alias Lalit Mohan Das. And that finding in the next reasons and decisions of second para, my lord, last line, my lord, the planet court came to the finding that last two lines, my lord, it is crystal clear that the proceedee is the daughter of Lalit Das, alias Lalit Mohan Das. So this issue is decided in affirmative, my lord. The learned court below, after perusal of documents and evidences, my lord, came to the conclusion that I am the daughter of Lalit Das, alias Lalit Mohan Das, my lord. My lord, the second issue is that if so, whether the name of the father of the proceeding as per reference is Lalit Das alias Lalit Mohan Das. My lord, from the reference itself, my lord, it is clear that the actual reference was drawn against somebody else, my lord. That lordship will find that find at page 53, my lord. That is the actual reference. Page 53, annexure P15, my lord. Paragraph 1, name of the name and the current is of foreign national is Jamuna Das, my lord.
Page 50.
53, my lord. That is the actual reference drawn by the police. Then in paragraph 13, my lord, in the same page, my lord, name and address of the other family members, my lord. That is daughter of Santosh Das.
But why
Which
will
is
you
somebody
entertain a
else, my lord.
repetition after 6 years?
My lord, I was severely ill, my lord. I have stated in my paragraph. My son was also mental patient, my lord. I have annexed the medical documents also, my lord. And the order was after 1.5 months, where the COVID also came, my lord. Therefore, no communication was made with the. And interestingly, my lord, the final decision, my lord, lordship will find at page 98, my lord. 98, my lord, paragraph 9, my lord. Considering the entire materials on record and the decision above, I am of the opinion that the proceeding, namely Jamuna Das, wife of Narayan Das, daughter of late Santosh Das. My lord, in earlier finding, the learned court below was decided or came to the conclusion that I am the daughter of Lalit Das, my lord. Here, the court has came to the conclusion that Jamuna Das, wife of Narayan Das, daughter of Santosh Das of village so-and-so, Nagaon, is a foreigner who entered after so-and-so, my lord. My humble submission is that when the learned court below came to know that the actual proceeding was against somebody else, my lord, and the petitioner is somebody else, my lord, the learned court below could have dropped the proceeding, my lord. Otherwise, my lord, after getting notice, my lord, I appeared, I submitted all my documents, 25 numbers of documents, and also adduced evidences, my lord. And all shows that I am a citizen of India, my lord.
Your plea. She claims to be the daughter of Lalit Das.
I am Lalit Das, my lord. And the learned court also, after perusal all the evidences, my lord, it came to the conclusion that I am the daughter of Lalit Das, my lord. And all my parents, grandparents were residing in here, my lord, since before 1966. I have adduced all the evidence, my lord. my lord, I have adduced the voter list of 1970, my lord, of my father, my lord, at page 23, my lord. Thereafter, voter list of 85. Thereafter, 93, my lord. My lord, I have adduced the school certificate and the school headmaster and the other teachers also adduced the evidence, my lord. And initially, my lord, my father was also filed evidence on affidavit, my lord, but subsequently he died, my lord. Therefore, cross-examination could not be done, my lord. And the learned court below also came to the conclusion that I am the daughter of Lalit Mohan Das, my lord.
Who's Santosh Das?
My lord,
Who's Santosh Das?
Santosh Das is a different person. I do not know, my lord. Actual reference was at his name, my lord. At the name of her daughter, my lord. Santosh Das' daughters, my lord. B. Chandu, my lord. B. Chandu.
In your opinion, keeping the issue of maintainability open, sir, the opinion is at page 93, dated 30/1/2020, passed by so-and-so, in case number so-and-so, reference number so-and-so, by which the petitioner was declared to be a foreigner post 1971. In order to delay in asserting the imperial open, keeping the issue of maintainability open on account of delay and latches, issue notice returnable on so-and-so, extra copies within 2 days, call for the records. The prayer for bail shall be considered on receipt of tribunal's records. In the meantime, if the petitioner, namely so-and-so, is apprehended, she shall not be deported out of the country without order of the court. Next paragraph. Petitioner shall cause production of a certified copy of the order before the Superintendent of Police border, Nagaon, to print the. This will be Nagaon.
My lord, the tribunal is at
Hojai,
Hojai, my lord.
Hojai,
Hojai, Assam, my lord.
Hojai, to bring the order to the notice of the said authority. List also.
17.
Yes, item 20. Okay, non-occasion call. Our so-and-so appeared for the respondents. Third so for the respondents. Opinion is page 57, dated in 16/9/2025, passed by so and so in case number so and so, police reference number so and so, by which the petitioner was declared to be a foreigner post 25 in 1971 street. Notice returnable in 4 weeks. Stock office within 2 days, call for the record. Prayer for bail is opposed by the learned standing counsel for the FT and bottom matters considering projection. 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border, Morigaon. 13-14 days on list of proposals.
Item, sorry, my lord, item 13 and 14 is, my lord, in item 13, my lord, the exit permit has been granted by the FRO already. So if your lordship directs, my lord, they can, if they arrange, they may be, your lordship may give a direction. Probably there are some orders where your lordship has directed the SP concerned to hand over them to the, my lord.
That I think we have already passed orders.
Yes,
in this
yes.
case.
But the exit permit will be only valid up to 20th month.
Protocol.
20th, next Friday, 20th July, madam. Otherwise,
No, but I think in the last order, we have already directed the state to deport to send them off.
it's proceeding.
Order is already there. Only to wait. Just wait for some time. Let the
Yes,
others
yes,
come.
yes. 21.
And inform Mr. Chakravarti, he was there.
Yes,
You will be here.
Yes.
Okay. No, Mr. Chakravarti appeared when the matter was called.
Yes, he appeared, but I think in this matter, she's been assigned with us.
Lordship, in this matter, the conducting counsel Keboro has some personal difficulties, Lordship. Kindly, Lordship, adjourn.
Just
21.
21. Okay. Your name?
Lordship M. Bhuyan.
Mr. M. Bhuyan and counsel for the petitioner and so and so for the respondents. Page 37. Opinion dated 21/5/2026, passed by so and so in case number so and so, district number so and so, by which the petitioner was declared to be a foreigner post 25/19 Swindon Street. Notice 4 weeks, call for the record, extra copies within 2 days. Prayer for bail is opposed by the learned standing counsel for the FT and borrow matters. 10 days time to take bail of these 5,000 to the satisfaction of Superintendent of Police Border, Lakhimpur, North Lakhimpur. List 4 weeks. Extra copies by tomorrow.
Item 13. 13.
See, paragraph 3, we already have now, right? No, first order. Answer in the order, this, para 3.
Yes, madam. This is there, madam. But in some one cases, your lordship has specifically directed the SP. Yes, your honor. What are some?
Now, Lordship, exit permit has been issued.
Oh, it's
So-
okay, because I remember giving that order.
Yes,
They'll facilitate.
yes, sir.
Facilitate by, everything is covered within that
Yes, yes.
facilitation.
The only
If
concern,
it has to be transported, if it to be handed over.
the only concern is that we need to book tickets. So if they give us a date that in so and so date we are going to get there, so we will book tickets and accordingly, that is the only, our exit permit is valid only till 20th
No,
July.
but have you applied before them and they refused you?
We have informed to the concerned SP.
No, these
Consent-
are not oral. Nothing can be done orally here. You have to say that this is the order, please give us the date so that we can book tickets for going.
So I'll make an application to the SP.
Yes, because they'll have to keep on record.
Has been full year.
Yeah.
It can't be at the will of the authority.
Yes, yes, madam.
They have to inform authorities, they also have superiors
I
to be
informed,
informed and then they do the inform.
On the basis of this order, madam, they can apply before yes.
okay.
I think it's 14. Third Swenso. Here, CGC, you'll be, Ms. B. Sharma, by CGC. Correspondence 1 and 2. Mr. P. Sharma, run at additional signature and advocate, correspondent number 3. And Mr. J. Pang, run standing also for the 50 and bottom matters. Next paragraph. It has been submitted at the bar that the exit permit has been issued by the appropriate authority to enable the petitioner to leave India to her country of origin. So it is submitted that the exit permit for the petitioner is valid till
27.
27.
20th July.
Exit on or before 27.
Okay, it is valid till 27/7/2020.
That's 27, 20th July.
207.
20th July.
Okay.
Yes,
20th
20th
July.
of July.
207/2026. So stop. Accordingly, it is the London Council for the petitioner pays to issue appropriate directions so that she can, that the petitioner can travel outside, travel to Delhi and thereafter to her country of origin. Next para. By order dated 26/6/2026, this court had already issued a direction that the pendency of this writ petition shall not be a bar for the concerned authorities, including the Ministry of External Affairs and Ministry of Home Affairs, Government of India, and the Home and Political, within bracket B Department, Government of Assam, to do the needful for facilitating the exit of the petitioner to a country of origin. Accordingly, it is open for the petitioner to make appropriate application before the authorities so that he can, the petitioner can be sent to Delhi for onward journey to a country of origin. In accordance with the procedure established for that purpose. So it is made clear that the cost of travel has to be borne, cost of travel in respect of the petitioner shall have to be borne by the petitioner. List when? Okay, the learned CEC and the learned standing officer for the FT and borrow matter shall inform the court,
20 is the date, so 22nd, Lordship.
shall inform the court about the status of the petitioner. Next para, list on, make it 22/7. Next, the second case also same.
No, Lordship,
Second case?
here,
Yes, we have, my lord,
yes, we applied.
we have facilitated and it is already applied, my lord. For
As
exit
per
permit,
my instruction.
so probably it will be within 2-3 days, you will get the mother exit permit.
Just
So
the
you'll-
latest instruction.
Second case you say, what so and so, huh? 8 to 14. So and so, the learned counsel for the petitioner has produced a copy of
It's my instruction.
letter dated T7/2026 issued by the Undersecretary to the Government of India to the Commissioner Secretary to the Government of Assam, Home and Political within bracket B, bracket close Department, as well as letter dated 7/7/2026 by the FRRO, Gauhati to the Inspector General of Prisons, Assam Prisons, Assam, to provide facility arrangements for the application to be made by the petitioner, online application to be made by the petitioner in the designated portal. Full stop. Next, by the learned CGC has informed that necessary facility has been provided for applying for the exit permit to leave India to the country of origin of the petitioner. Full stop. It is submitted that perhaps the matters would be processed within a couple of days. Full stop. Next para. In the meantime, if the necessary exit permit is granted for the return of the petitioner to a country of origin, it would be open to the petitioner to apply for travel to Delhi for onward travel to her country of origin. Stop. If such an application is made after receipt of the exit permit, the same shall be processed to facilitate exit of the petitioner to her country of origin by following the procedure established for the purpose. Next, it is made clear that the cost of travel for the petitioner shall be borne by the petitioner. List same 22. Just before that, you said we'll keep it on record. This is
Item 23.
Next, we will also. Lordship, this matter may kindly password for the day, Lordship.
That's fine. Opinions of 2024. You are issuing notice, but you'll have to wait for some time for bail. Third miss,
S.R. Major
H.
S.R. Major
HR Mazul run counsel for the petitioner. And also for the respondents. Page 56. Opinion dated 28/2/2024. Passed by so and so in FT case number so and so, IMDT reference number so and so. Reference FT case number so and so by which the petitioner is declared to be a foreigner post 25/1971. Notice returnable on so and so. Extra copies within 2 days. Call for the records. The prayer for bail shall be considered on receipt of the tribunal's records. In the meantime, if the petitioner Muhammad Makram Ali is apprehended, alias so-and-so is apprehended, he shall not be deported out of the country without order of the court. So the petitioner shall cause production of a certified copy of the order before the Superintendent of Police border, Nagaon, to bring the, no, it will be Hojai, I think. Hojai, to bring the order to the notice of the said authority. List on so-and-so. August.
Yeah.
24,
What's this one? Yes, item 24. Opinion is at page 53. Okay, none appears on call for the petitioner. I was heard so-and-so for the respondents. Opinion is at page 53. Dated 31/8/2024, passed by so-and-so, in case number so-and-so, reference number so-and-so, by which the petitioner was declared to be a foreigner post 25 to 1971. Notice returnable on so-and-so, extra copies within 2 days. All for the relevant records. If the prayer for bail shall be considered on receipt of travelers records. So in the meantime, if the petitioner, namely Muhammad Jasnara Khatun, is apprehended, she shall not be deported out of the country without order of the court. Except the petitioner shall cause production of a certified copy of the order before the Superintendent of Police border, Nagaon, to bring the order to the notice of this authority. List also.
item 26,
Wait, please. Protective Indian order is a page number 47 you look at, and is the
Page
47.
'47. Okay, had Mohammed A. Rahman, learned counsel for the petitioner, and so for the respondents. Opinion at page 47, dated 24/1/2024, passed by so-and-so in BFT case number so-and-so, FT case number so-and-so, by which the petitioner was declared to be a foreigner post 25 to 1971. Notice returnable on so-and-so, extra copies within 2 days, call for the relevant records. Prayer for bail shall be considered on receipt of tribals records. Next, in the meantime, if the petitioner, namely so-and-so, there are 4 areas, is apprehended, she shall not be deported out of the country without order of the court. Next, petitioner shall cause production of a certified copy of the order before the.
Yes.
Again, you'll have to make, you'll have to file an IA for correction.
Lordship.
There is no Superintendent of Police border Kamrup. Has to be Deputy Commissioner of Police.
Lordship, I will file, immediately.
No, not TV. It will be Superintendent of Police.
Yes, yes.
Kamrup,
Rural
not
area.
metro. it is.
Okay, come in,
Yes,
okay.
Lord.
Certified copy of order before the Superintendent of Police border Kamrup Amingaon, to bring the order to the notice of the said authority. List on so-and-so.
Obliged.
upgraded item for orders, item 43.
Oh. That's it. On earlier occasion, respondents took time to file affidavit also.
Will stay the operation of the impugn notice,
Yes.
but it is subject to payment of 25% of the demand on under process, subject to, which will be subject to orders of the court. 25% demand.
Subject.
That will be subject to orders of the court, not to be appropriated. Stand Deca, Learned Senior Counsel for the Learned Assistant Management.
M. Google.
M. Gogoi, Learned Counsel. Applicant. For government, you are there. Pablo.
Union is a party. It's a formal party.
There's Urban Development Department.
I'll be appearing for Union of India.
Dipankar Nath was appearing, my lord, on the last occasion, as far as I remember.
7 and 9, you can appear. You'll be appearing for?
Union of India. Respondent number 1.
Urban Development Department. Dipankar Nath was appearing.
Heard Mr. Ashim,
Chaudhary.
Chaudhary, Learned CG for respondent number 1. And Mr. P. Sharma, and additional senior government advocate appearing for respondent numbers 2 to 7 and 9. None appears on call for the respondent number 8. Next para. Although the learned counsel for the respondent numbers 2 to 7 and 9 had were given an opportunity within 2 weeks' time by order dated 27/11/2025 to file objection, but no affidavit in opposition has been filed in this application. Next para. The learned senior counsel for the applicant has paid for 1 interim relief. To stop, it has been submitted that prior to the issue, initially the Namrup Township was being maintained by the applicant.
Brahmaputra Valley Fertilizer Company.
Namrup, what is Namrup?
It is the township of the company, my lord. It was supposed to be taken up in the Namrup Town Committee, included.
By the applicant company. So however, the said area was declared to be a municipal area, and thereafter the Namrup municipal board have issued notices demanding municipal tax from the applicant for the financial year 2023-2024 and 2024-2025. And comma amounting to rupees 13, comma
76934.
13, 76, 934 for each financial year. Next paragraph. Considering the fact that demand notices have been issued and no objection has been filed till date, the court is inclined to provide that as an interim measure, the interim measure and till the next returnable date, subject to payment of 25% of the demand for the financial year 2023-24 and 2024-2025, the notice of demand dated 8/8/2025, page 11. This number also, capital N, small rp, again capital M, capital B, numerical 4, oblique establishment ESTT, full stop, oblique 25, oblique 407, dated 8/8/2025. And the demand for property tax for the said period shall remain state. Next para, it is further provided that the 25% of demand paid by the petitioner, applicant, shall be subject to further orders of the court. Next para. List on, give a date after. Where is the main matter fixed?
There is a date fixed, my lord, because they have also not responded to the appeal, if at all it is required.
Give a date after 2 weeks. List on so and so, and in the main appeal, you also say both sides except respond number 8 are represented. List the matter on 31 July.
My lord, I'll not be there, my lord. Can it be in the second week of August, my lord?
Second week of August.
Yes, my lord. 10th or 11th?
Make it 10th. 10th of August.
Only prayer was, my lord, since lordship has directed deposit of the money, can the interim order be till disposal of the retrieval, my lord?
No, let us see what objection they file. It's a question of revenue.
Oh, man.
You have to balance both sides
Mal.
when it comes to revenue.
For orders, upgraded item 44.
Lordship, 117 days delay in preferring appeal, but in the last order, Lordship has reflected that we have joined 5 petition together because common judgment was passed in this particular case. Lordship, that is why, Lordship, we have taken the instruction, we'll delete the name of some of the appellants. I'm giving a list, Lordship, of this writ appeal. That is WPC number 6020 of 17, and WBC 3273, and we have given the list and name of the appellant.
Yes, so
So we'll delete the name of the, let me be stock of lordship. The appellant number 7, 12, 14, 9, 15, and 18, and 17. That may be stock of lordship for the name of the petition.
this appeal relates to the WBC 6020.
Lordship. No, not only 6020, 5741, and 6020,
Oh, it's a,
3270.
it's a correct, what you call common appeal.
Common appeal. On last order, lordship will reply everything. Lordship, there we have joined the appellants for a common judgment.
Any difficulty in filing an application for deleting their names because it is substantive?
Also, we can
what do you
also file a separate
Huh?
application. Also.
Pardon me?
We can file a separate application also.
I think that would be better because then the
Only to save the lordship the paper, we have filed this common appeal because of the common judgment.
and we
But now
understand.
we have to file a separate application. You can file also. Only
No, we are not on separate appeal or something, but if it is deletion of names, I think somebody must take responsibility that they are withdrawing their names. Otherwise,
because we will get a liberty to file a separate appeal in the name of the present appellant, which should be deleted.
so therefore, we need an application to do that.
Lordship. We'll file a separate application.
So that makes it easier
Lordship.
for the court, instead of passing so much orders. Because of that notification which has come out in the meantime, which says that if it is done at the instance of the party, then the application has to be filed. Only in cases of suo motu orders where the court wants imprisonment, then this application is not required. So because of that notification, we want an application. Okay. Heard Mr. S.K. Goswami, Leonard, counsel for the applicants. Mr. Athaya, you are for?
R2, 3, 5, and 6, BTC lordship. I pay for BTC. Respondents 2, 3, 5, and 6.
Okay, for education department, you are there. Your name? B. Deca. B. Deca, Ms. B. Deca, Learned counsel for respondent number 1, and Mr. A. Athaya, Learned standing counsel for the BTC, representing respondent numbers 2 to 5. Next, brother. The learned, referring to the order dated 2/6/2026, the learned counsel for the applicants pay for some time to file an application for deletion of names of certain appellants. Full stop. Prayer is allowed. The matter stands adjourned today. When?
After 2 weeks.
Hmm?
After 2 weeks also.
Okay. As next, expect for this after 2 weeks.
Or less.
And in the meantime, you take instructions that if the subject to that application, it's on the question of delay of 117 days. You may be inclined to allow that.
Yes. Already delay has been condoned in separate appeals. in same day.
Okay. Then what is this application form?
Application for delay, Lordship, 120 days delay. This application was heard and court has interested to continue the delay. That time it came to the notice that separate this petition.
Okay, okay. Hmm.
45.
May please about it. This is a delay condemnation petition, so the delay of 201 days. The last petition notice were issued and
201.
201 days of delay.
Any strong objection?
There was
My lord, in fact, the writ petition was dismissed on the ground that it is a frivolous, my lord, application for personal gain. And the writ appeal, my lord, is on for interfering with the imposition of cost. Now, my lord, my humble submission is that your lordship will consider, my lord, the grounds are cited at para 2, 3, and 4. My lord, my humble submission, my lord, that those does not constitute sufficient cause, my lord, in terms of section 5. In 2, my lord, para 2, the appellant say that, my lord, the delay had caused because they did not know about the disposal of the writ petition. Now, nothing, my lord, has been indicated as to when they came to know, how they came to know. The para 3, my lord, it says, my lord, that the appellant number 1 was suffering from old age. This is one of the grounds. And para 4, my lord, they have stated that they are very poor persons. my lord.
That's
Financial hardship. In the judgment, my lord, at page 79, para 16, the relevant part, my lord, is recorded by the Honorable Court. This court, for the reasons recorded herein above, and based on the materials available on record, it is of the unsistent view that this writ petition is devoid of merit and frivolous litigation for undue gain. Categorical assertion, my lord. My lord, the Honorable Court had relied, my lord, on a Supreme Court judgment which is extracted at para 8, my lord. In that case, my lord, the Honorable Supreme Court was pleased to impose 10 lakh cost for for filing false affidavit, suppressing facts, my lord, etc.
this is the administrative as my thing.
Yes, my lord. My lord, my humble submission is, my lord, the grounds, my lord, they do not, my lord, constitute sufficient cause, my lord. Financial condition and illness, my lord, one of the grounds.
I actually have a little bit of problem with this matter. See, I cannot go against the council concern, so I'm not making any specific argument. My learned friend is also very correct. Whatever I stated may not be in a very clear terms for a condemnation of delay. I understand that because there are some issues I cannot go. I cannot go against a council. So I have to balance it. Only thing, your lordship, was the issue, since he has already gone into the merit, that also I'll not go. I'll just point out one thing. On the very first day, the matter was mentioned for withdrawal, but it was not allowed. And ultimately, these things came up. Anyway, there were some irregularities. I found it. It was there in the report. I was not the counsel then. So there was there in the, because specific names have been stated with regard to the person concerned with the, either the department, as well as there is a, I think, name of one of the counsel who has given the legal opinion has also been inserted. Maybe because of those reasons, it was, I think, was to be withdrawn, but it was not allowed. Withdrawal was not allowed. And ultimately, whatever, it went dismissed or not, but the part was actually, I was requested only on the ground that, that 1 lakh part, that these people are not the persons who can pay those amount. That is why I have come. Otherwise, I wouldn't have appeared in this matter at all. And with regard to what my learned friend has submitted, I am not opposing anything. I'll leave it to your lordship. Now I have to balance for one of my colleague, and I don't have anything against him also. As the matter has been dismissed, there is nothing remains, your lordship, whatever.
I leave it to lordship, my lord. I have made my submission.
This time, both of us leaving to your lordship.
My lord, I say, my lord, that, in fact, some signal should go because the apex court has also said, this is not done, my lord, with the judicial, my lord, process.
Actually, this is the problem, you know. I cannot go against my colleague, your lord, whatever be the reason.
Yes.
Whatever, your lord.
That can be done, my lord, right now. That can be
Yes.
done. I agree to that, my lord.
Yes, I know that. That's why I'm not arguing anything. And the council has drafted this. He cannot put his claim. What can I do, your lord? Yes.
Whole day.
Yes. Sure.
Lordship may give a quietus, lordship may give a quietus to that. As your lordship has said, my lord, I agree to that, lead appeal may be disposed of, my lord.
Yes, it can be done today.
Mr. Y. Manan, counsel for the applicant. And Mr. S.K. Talukdar, standing counsel for the Cooperation Department, representing respondent numbers 1 to 5. And Mr. P. Sharma, additional senior government advocate, representing respondent number 6. Next para. By filing this interlocutory application, the applicants were the appellant in the connected unregistered intra-court appeal has been paid for continuing a delay of 201 days beyond the period of limitation in filing the connected appeal. Next paragraph. Learned counsel for the applicants have submitted that the applicants are suffering from acute financial hardship and the have filed the connected intra-court appeal, agreed by the cost of rupees 1 lakh imposed on the applicants. So we have submitted that the purpose of the connected intra-court appeal is only for the only in respect of the imposition of cost on the applicants. Next paragraph. Per contract, the learned standing counsel for the FT and border matters, the Corporation Department has submitted that is no material to support the contention of the applicants that they are suffering from financial hardships. And moreover, they have not disclosed as to when they actually came to know about the order of the court, which is impugned in the connected intra-court appeal. To stop, it is in respect of the issue of cost, the learned standing counsel for the Corporation Department has submitted that as the learned single judge had held the writ petition to be frivolous, and in that regard, reliance was placed on the case of, just find it out, that the full name, Messrs. M/S, full stop, Scheme, SCIEMED, Overseas Inc. INC versus so-and-so, AI 2016 SC 345. And it is submitted that in that case, the Supreme Court of India had imposed a cost of rupees 10 lakh on the petitioner for filing false and misleading affidavit. Next paragraph. Be that as it may, in view of the submissions made by the learned counsel for the applicants with that the connected appeal is only in respect of the cost imposed by this court, the court is of the considered opinion that the that on facts unique to this case, without intending this order to be a precedent, the delay of 201 days beyond the period of limitation is hereby condoned. Most of the registry shall register the connected intra-court appeal. Next paragraph. The next order will be in the writ appeal. This heard so of the appellant. Mr. Manan is for appellants, and they will be for respondents now. Mr. SK Talukdar for 1 numbers 1 to 5, and Mr. P. Sharma, additional senior government advocate for respond number 6. Next one. Ban order passed. In the connected IA Civil 678 of 2026, the delay has been the delay in filing this intra-court appeal has been condoned, and moreover, the direction has been issued to the registry to register the connected to register this appeal. Next para. By filing this intra-court appeal, the applicants, the appellants have assailed only that part of the impugned order. The judgment and order dated 24/6/2025 passed by the learned single judge in WBC 2016/2025. From which relates to imposition of cost of rupees 1 lakh to be paid by the appellants jointly. Next paragraph. The learned counsel for the appellants has submitted that as per his instructions, the appellants are having poor financial condition and are unable to pay the cost of rupees 1 lakh. Next, though the learned standing counsel for the Corporation Department has opposed the prayer, by citing the case of Messrs. Kimed Overseas Inc. versus so and so, AI 2016 SC 345. Next. Next paragraph. It is noticed that the learned single judge took into consideration the irresponsible scrupulous SCURRILOUS statements made by the appellants against the Registrar of Cooperative Societies as well as against the learned departmental counsel for the Cooperation Department, amongst others, not only dismiss the petition but also impose the cost. Next. In this regard, accordingly, the court is of the considered opinion that as the learned single judge has arrived at a finding of fact that scrupulous attacks have been made against the learned standing counsel for the Cooperation Department without any cogent material. And the further allegations of the against and further substantiated allegations against the registrar of cooperative societies of indulging in illegal activities is a good and sufficient cause for the court not only to dismiss the connected writ petition for making such irresponsible and scurrilous statements. First of the scurrilous attacks on the standing counsel for the Corporation Department also has to be deprecated. So therefore, there is no apparent reason for the court to take any other view than what has been taken by the learned single judge. Next, however, taking note of the plea that the petitioners are not in good financial condition, the court is inclined to reduce the cost to rupees 40,000 within bracket rupees 40,000 to be paid by the petitioners by the appellants jointly and severally. Full stop. From the date of the order, 30 days time is granted to the appellants to deposit the said cost before the District Legal Services Authority, Barpeta. I've said 30 days, no? 30 days. Full stop. The applicants the appellants after making such deposit shall produce a proof of such deposit before this court within a week thereafter. Next para, in the event, it is further provided that in the event in the event proof of deposit of such cost is not produced before this court within a period of within the period allowed, it would be open to the District Legal Services Authority, Barpeta, to proceed to recover the amount to the Office of the Collector, Barpeta, by treating the same as areas of land revenue in terms of Bengal Public Demands Recovery Act, 2013. Okay, Mr. Manan, we have a second view in this. If we have to recover the money, then we say 1 lakh rupees, because it has to be voluntarily deposited and shown. The question of land revenue, if we make an execution, it takes a lot of time. So for 40,000 rupees, the DSA would be engaged in the Bakijai proceedings. So should we say that if the cost is not deposited, then the orders will stand recalled and the original cost will stand restored?
Lordship can do that.
Okay.
In fact, actually, what has happened on the very first day of this matter, in the motion,
No, we accept your statement.
that part can be recorded, Your Lordship, so
We-
that then.
No, we don't know because that whether it is recorded or not. we
No,
don't
that is recorded in the order. Anyway, the Lordship can do that. I'll inform them. We'll
It is
deposit.
the
Then your Lordship can put it in 30 days part, maybe a little bit more, so that I can inform them then this order can be,
Oh, okay, for 45 days, 30 days make it 45 days. Huh?
that will be better.
Next para, if it is made clear that if the proof of deposit is not produced before this court within a period of 10 days thereafter, this order would stand recalled and the original cost of rupees 1 lakh as imposed by the learned single judge by impugn order dated 24/6/2025 passed in WPC 2016 of 2025 shall stand restored without any further orders of the court. Next para, it is made clear that the order can only be uploaded after the registration of the writ appeal. Therefore, the uploading of the order may be delayed till the registration of the appeal. Because these orders would not be uploaded unless it is registered. So we have made it clear in the order. It will take at least 2 days time to have it restored. You take a short break and come back.
For admission, item 27.
Check the records.
Lordship,
Res judicata, they are invoking the principles of res judicata. In one opinion, has been declared to be a foreigner, but that order is practically a non-speaking order, but no appeal has been filed.
Page 78 now.
Pick it up after some time.
Lordship.
He'll come at 2 o'clock. Give it time, he'll go through it. Which page is the opinion?
My lord, opinion is page 20, my lord. The impugn opinion, my lord.
Impugn opinion at page 20.
20, my lord. And my lord, regarding my lord, the earlier case, my lord.
Earlier opinion at page
Earlier, my lord, opinion at page 78, my lord.
78.
The opinion, my lord, at page 80, my lord.
Just check it is not, otherwise non-speaking order, but states opinion. Bound by it at 2 o'clock.
Okay.
Item 28.
Next, my lord. But in this matter, earlier engaged counsel is, no more engagement in this matter, your lordship, we will file wakalat, my lord. Lordship, some time may be given, your lord.
Which is represented on the prayer made by learned counsel for the petitioner. The matter stands adjourned today. List on. Give a date after 2 weeks.
Obliged.
99.
May I please, Your Lordship?
This item, if possible, may take another day.
Hmm?
If possible, then take another day. I will contact them with some instruction, I will take my, but it could not contact over phone number. Phone number is changed.
Which page is the opinion?
But opinion is page,
51.
yes, 50. Finding is that he failed to establish linkage with his father.
Just a moment.
Some place.
Item 30.
May I please the losses, my lord, lordship may please to accommodate me for the day losses. Opinion is page 51 losses. On 22nd. Oblige.
31.
Please, your lordship. Madam, exam for a day, lordship. Madam, the exam for a day, lordship. For that.
It's bring for adjournment.
Adjournment.
the TCR has not been received. So next, accordingly, the registry shall take, shall issue a fresh notice, a fresh requisition for the TCR from the concerned learned tribunal. Next, the requisition shall be sent to the following email address of the learned tribunal. Next, list on so and so, awaiting receipt of the TCR. Give it after 3 weeks.
Tenth of August. Item 32.
Your lordship, there is another courtroom. Kindly allow a short pass over.
For the time being,
Yes, your lordship.
time.
Much obliged.
Thirty-three.
Okay. Who will file Wakalatnama lordship in this matter also, your lordship? Who will file Wakalatnama in this matter? Earlier councillor are no more engaged in this matter, your lordship. Sometime maybe.
Your SOPs have been notified for the tribunals, no? No. Mr. Payan?
It's not yet notified, but it will be notified soon. We have
Not notified.
not yet notified.
There's a,
I've discussed it, Malad, they will be.
there are
notified.
two orange flags in the file. Then look at the last page of the order sheet. Page 6 of the order sheet, I've given green flag there. Ah, that's it. Page 6 of the order sheet. Put a green flag, yes. Hit the last two orders, and then go back, next page. The argument is over. Written argument filed.
Yes.
Then fixed for delivery of orders, next
Another.
page, yes. On the date of judgment, the exhibits are more accepted. We have got nothing to say, but we have passed whatever judicial orders we required to be passed, but if the government is not acting on it, law will take its own course. We adjourn the matter today, take it up next week. In the meantime, the government does not want, then we should stop making statements. Both sides are represented on the pair made by the counsel for the petitioner. The matter is adjourned today. Please stop. Give a week next week. Yeah. And you see the process of the tribunal accepts the petition, makes three exhibits a part of record, and then records the objection by the government pleader. Can that be done? That means I will dictate my order, and then I will say, Mr. Payang objected to the.
Obliged.
34. Item 34.
none appears on call for the petitioner, all the respondents are represented. For ends of justice, the matter stands adjourned today. So it is made clear that if petitioner remains absent on the next date of listing, adverse orders would follow. Give a date after 2 weeks.
Item 36 for admission.
May I please, Your Lordship? So this matter may be taken next week.
Next week. Which page is the opinion?
Yes, 73, Lordship. Annexure 15. Maybe another day. Fourth or fifth.
Yes, come to page 45. And turn over to page 46.
Yes,
Now it is Pradharko Ghat,
yes, yes,
Moor Namor Ukta,
yes, Lord.
Hukumar copy.
Yes.
How can this become 5?
Oh, yes. It should be 8, Lord.
Sign police are 5. You can. Okay, the original record it is 8 only. Sorry, yeah, 5 only. It is 5. See what this is what is happening. We told you this procedural something is very wrong. That's you put an orange flag.
Lord.
You have seen the evidence on affidavit. It is
Yes, sir.
exhibit 1 to 8. Now look
Yes.
at the flag.
Yes.
In the flag in cross-examination, the tribunal changes the exhibits. Is it fair? Can they do it like this? And is this cross-examination?
Yes.
So you are forcing the party to forego 2 exhibits.
Yes.
3, in fact 3. Now you need to send back at the stage of evidence. You have to expunge the cross-examination.
Yes, Lord.
And this, very interesting. Have you seen this flag?
Yes, yes.
Please read one, any exhibit at random, 1 to 5. Read anything at random.
1971 চনৰ আলিপুৰদুৱাৰৰ ডিষ্ট্ৰিক্ট মেজিষ্ট্ৰেট আৰু ইলেকশ্যন অফিচাৰে ইছ্যু কৰা ভোটাৰ তালিকাৰ চাৰ্টিফাইড কপি জলপাইগুৰি জিলা আলিপুৰদুৱাৰ মহকুমা পশ্চিমবংগ ৰাজ্যৰ ভোটাৰৰ নাম ক্ৰমিক নং 116 ঘৰৰ নং নীল দত্ত সুৰেশ চন্দ্ৰ সম্পৰ্ক ব্যক্তিৰ নাম দেৱ প্ৰতাপ বয়স 53 বছৰ অপৰপক্ষৰ মাকৰ নাম উল্লেখ নাই এক্সিবিট 2 1989 চনৰ ভোটাৰ তালিকাৰ চাৰ্টিফাইড কপি নাওবৈছা বিধানসভা সমষ্টিৰ
Anyone at random. We don't read everyone.
Yes.
But you see, this is not cross-examination.
Yes, yes.
This is question and answer. It's not cross-examination. And in the cross-examination, in the name of cross-examination, whatever is not there in the evidence, all those filling the gaps are filled up.
Yes.
Even for 5. But how can the tribunal do it? You see, they can understand the tribunal dealing with the evidence.
Yes.
But this is not the way to deal with the evidence. Third, Mr. L. Sarkar, I am counsel for the petitioner and so for the respondents.
My lord, rely on this one doesn't. There are 23 to 26. 23 to 26, my lord. May I read, my lord?
No, there's Abdul Quddus. We don't need this.
Yes, Abdul Quddus also discussed and mentioned here in this case.
Abdul Quddus is reading on the foreigners issue. Don't require this. dispute. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated page 29, 33/2019, passed by so and so and so and so, thereby declaring the petitioner to be a foreigner of post 25 to 1971 stream. Next paragraph. In view of the nature of order which is proposed to be passed, the court does not find any reason to burden this order with the pleadings and evidence of the parties. Next, it was suffice to mention that on being referred by the Superintendent of Police within bracket border, bracket called Lakhimpur, North Lakhimpur, the Lakhimpur within bracket Lakhimpur FT within bracket first, bracket was case number 4064 of 2011 was registered. So the records reveal that in the written statement, the petitioner had disclosed that previously a case was registered against her before the same learned tribunal, which was registered as Lakhimpur FT-1 oblique case number 6311 oblique 16, bearing district number 07 oblique 15, by which she was declared to be a foreigner declared to be a citizen of India and not a foreigner, by opinion dated 15/12/2016. The copy of this said opinion dated 15/12/2016 was referred to as Exhibit 8, Roman 8, in the evidence on affidavit filed by the petitioner. To stop. Page 42. Yes, sir. Next fellow. From the evidence on affidavit of the petitioner who examined herself as DW1, comma, it is noticed that she had, that she had exhibited the following 8 documents. Page 42, huh? Okay. Exhibit 1, Exhibit 2, Exhibit 3, 4, 5. Next page, 43 is 6, 7, and 8. Full stop. The as per the tribunal's records, comma, the evidence on affidavit was submitted on 10/12/2018. Full stop. it may be also stated that against all the exhibits, it was mentioned that those exhibits were copies, oblique photocopies. Full stop. The petitioner was cross-examined on 29/12/2018. Full stop. However, the learned tribunal in guise of recording cross-examination had omitted and oblique or excluded 3 exhibits of the petitioner, and being exhibit 2, 3, and 4, which is which were copy of the sale deed dated 26/10/1964 purported to be land purchased by the petitioner's father, photocopy of this will be 2, exhibit 2, photocopy of the pata of in the name of her father, within bracket exhibit 3. 3 is Roman 3, huh? And land revenue paid receipt for the said land, exhibit 4. There is no corresponding order in the order sheet as to why 3 documents were excluded. Full stop. The tribunal's records reveal that remaining by excluding the 3 above referred exhibits, the other exhibits were recast as exhibit 2 to 5, and all the 5 exhibited documents were stated to be proved in original. As stated above, there is no order sheet as to what compelled the learned tribunal to discard 3 exhibited documents. Full stop. Moreover, it is noticed that if the petitioner has filed exhibited documents along with the evidence on affidavit, there was no reason for the learned tribunal to remove those 3 documents and place it elsewhere in the record. Moreover, it is noticed that the exhibit 2, exhibit 3, and exhibit 4 now, out of the discarded documents, exhibit 2 and exhibit 3 are available at page 69, 70, and 71 of the TCR. And it appears that the said Exhibit 2 and Exhibit 3 were countersigned by the learned member on 8/12/2016. No, only Exhibit 2, not 3. Exhibit 2. So, photocopy of Exhibit 3 containing photocopied impression of signature of the learned member on 29/12/2018 is available at page 73 of the TCR. Oh, no, this is, no, strike out that last one. This is voter list. Next one. The learned tribunal, by referring to Exhibit 5, which was the opinion of the earlier foreigners tribunal cases against the petitioner, made the following observation. Page 32, Exhibit 5. Pencil mark. Stop. Next paragraph. The learned standing counsel for the border and FT matters has made its submissions in support of the impugn opinion. To stop. Next paragraph. On a consideration of the materials available on record, the court finds that Exhibit 2, there is no order as to why Exhibit 2, 3, and 4 mentioned in the evidence on affidavit of the petitioner was discarded, and what compelled the learned tribunal to renumber the exhibits as other exhibits as Exhibit 2 to Exhibit 5. Full stop. The learned tribunal was not sitting in appeal over the appeal or review against the opinion passed in LFT case number 6311 of 2016, and therefore the said learned tribunal could not have observed that the documents were not proved in accordance with law. So stop. Next paragraph. It is no longer res integra that by the decision of the Supreme Court of India in the case of Abdul Quddus versus Union of India, within bracket 2019, bracket 06 SCC 604, the Supreme Court of India had held that the principles of res judicata is applicable in cases of quasi-judicial authorities like the foreigners tribunals. To stop. The said position was reinforced in the decision of the Supreme Court of India in the case of FAIME Makers Private Limited versus district deputy registrar, cooperative societies, and others. Within bracket 2025, bracket post 5 SCC 722. Next. Therefore, the court is of the considered opinion that the earlier opinion of the Foreigners Tribunal, first Lakhimpur, North Lakhimpur, dated 15/12/2016, passed in at page 82, passed in so-and-so, could not have been discarded by the same learned tribunal in a subsequent, in the imperial opinion in a casual manner. Next, Bella. It may be appropriate to mention herein that the case of the impugn opinion was passed on 30/3/2019, and the decision of the Supreme Court of India in the case of Abdul Quddus was delivered on, just keep the date aside, huh? It will be 17/5/2019, I think. But this will correct it, huh? Full stop. However, since the principles of res judicata was decided, that would have a binding effect also on the on this court, and therefore the impugn opinion 33/2019 would not be sustainable on the grounds of principles of res judicata. Stop. Moreover, it may also be further mentioned that the leading judgment on the application of principles of res judicata to quasi-judicial authorities is laid down by the special bench of the Supreme Court of India of 7 judges in the case of Ujjambai, UJJAM, BAI versus State of UP and others, AR 1962, SC 1621. Wherein it has been well established that any quasi-judicial authority cannot take a view contrary to the coordinate or predecessor authority at an early point of time. Full stop. It has been further laid down that a mere misconstruction of a provision of law does not render the decision of a quasi-judicial tribunal void, within bracket, as being beyond its jurisdiction, bracket closed, full stop. It is a good and valid decision in law until and unless it is corrected in the appropriate manner. Full stop. Next paragraph. Therefore, so long as the earlier decision of the same learned tribunal in dated 15/12/2016, passed in Lakhimpur FT1 case number 6311 of 2016, page 82, stands, the same must be regarded as one authorized by law unless the said earlier decision was set aside in an appropriate forum and manner prescribed by law. Next part. Accordingly, the impugn opinion dated 30/3/2029, page 33/2019, page 29, passed by Spencer is hereby set aside. Next paragraph. Matter is remanded back for a first decision by the said learned tribunal from the stage of cross-examination of the DW1 next paragraph. The matter has been remanded for a first decision from the to be taken up from the stage of cross-examination of DW1, because it is in course of the cross-examination of DW1 that the 3 exhibited documents were discarded by the learned tribunal, which is not found to be in accordance with law. Without a corresponding order disclosing reasons as to why the 3 exhibited documents were discarded, the act of the learned tribunal in discarding the 3 exhibited documents in guise of cross-examination is also not found sustainable. Next paragraph. Reputation stands allowed to the extent as indicated above. The petitioner, who is duly represented by a learned counsel, shall appear before the said learned tribunal, give date after 1 month, tribunal on or within the outer time limit of 14/8/2026, and by producing a certified copy of the order, wait for further orders to be passed by the said learned tribunal. Next, the ministry shall send back the records expeditiously. The tribunal's records expeditiously back.
Time being item 32 for admission.
It please your lordships, the learned counsel appearing for the matter is still engaged in another courtroom. The lordships may kindly adjourn the matter for the day.
Mr. Friday will be. Okay, both sides are represented on the prayer made by learned counsel for the petitioner list from Friday, 17/7/2026. No adjournment on that day.
For orders, item 37.
But this is, my lord, probably this should be placed before the appropriate bench because these are this 19 men. 1/9. This is the order which they are seeking review by.
No, there's already administrative order.
Then, but nobody is checking. I think there is no ground, my lord, specified in the ground. The sole ground is at page 8, my lord. 2-3 grounds. This does not come under review jurisdiction, my lord. Where is the error apparent at the place of the record? That has not been mentioned. There is no ground.
No, it will continue with our bench. There is an administrative order of the Honorable Chief Justice.
Yes.
It will be taken up by the division bench too.
No, I'm not on that, my lord, if your lord,
Ah.
my lord, I'm on the merits, my lord.
Okay, okay.
Page 21 is the, my lord, the 19 is the judgment of this noble court, my lord. And the discussion there in page 20 from para 2, my lord. Para 2 and 3 is enough. This is quite a discussed every
You are referring to
page 20 of
page
this.
20?
Yes.
Okay.
It starts from page 19, but if your lordship may kindly see page 20 from para 2, for the purpose of, my lord, discharging the burden. This is the discussion. 5 exhibits were there. All has been discussed. Exhibit 1, Exhibit 2, then Exhibit 3, Exhibit 4, Exhibit 5. And then conclusion is page last statement. Although the tribunal recorded discrepancies in the age of Ustam Ali as recorded in the voter list of 1971 and the voter list of 1997, so also the name of projected fathers as well as whether it is Kisamot or Usamot Ali, we are of the opinion that primary consideration is whether the petitioner could conclusively establish his link to her projected father Ustam Ali or not. Ustam or Kismat is not the issue here, but whether she could establish or not. That is the only point. No documents whatsoever were produced and exhibited to show any kind of relationship between the petitioner and Usmat Ali. None of the 5 documents brought on record establish any link. Having regard to the same, the petitioner utterly failed to prove herself that she is the Indian citizen, chosen, reliable, and admissible. This is the sole point, man. Now, what happened? Why they are preparing this review, my lord? They approached the Honorable Apex Court by challenging this opinion. They approached the Honorable Apex Court. Page 22 is the order, my lord. Withdrawn it. But this is common practice. And said that they will file a review in the High Court. They withdraw it. Yes. Review grounds, my lord. That's why, my lord, page 8 is page 8 is grounds are there in page 8, madam. Court if the order that is going to be visited for error of law apparent on the face of the record. Where is that, madam? That is not. Then second ground for that all the relevant documents exhibited before the learned tribunal as well as the new documents annexed with the concerned restriction clearly showed that Usmat Ali is the father of the applicant, but the Honorable Court failed to appreciate that this visual aspect of the matter, and by dismissing the writ petition, affirming the findings of the learned tribunal, as such, same is liable to be reviewed for the ends of justice. For the Honorable Court could not have decided the petitioner that their main thing is that argument is that it should have been remanded instead of dismissing as per ground number C. 11C. For the Honorable Court would not have decided the petition on the basis of material laid before it and on the basis could have set aside the erroneous findings of the learned tribunal below. Where is the error, man? Counsel is not. But these review petitions are pending by since 21. And
none appears on call for the petitioner. However, however, all the respondents are presented. For ends of justice, the matter stands adjourned today. Next, this on, make it tomorrow, 14/7/2026. The petitioner remains absent on call on the next date of this week. Adverse orders will follow. Adverse orders or disposal on merit will follow. Okay. We're listing it tomorrow.
yes.
38,
Lordship, I am appearing on behalf of the Learned Counsel, Mrs. B. Gogol. Due to the unavailability of the Learned Counsel, Lordship may kindly adjourn the matter for the day.
What says, what says the representative on the prayer made by the council for the petition? The matter stands adjourned today. List again on. Give a date next week. Yes. Take it after some time. Next week. Okay. Next week at a date. Motion.
Item 39.
On occasion call for the petitioner. All the responses are presented. For ends of justice, the matter stands adjourned today. Next again on Wednesday. Next, it is made clear that if the petitioner remains absent from the Institute of District, adverse orders would follow, and of the court, the matter would be decided on merit.
Twenty-two-seven. Item 40.
May it please your lordship. Lordship, my senior is coming. Kindly take this matter after some time, my lord. Obliged.
Forty-one.
May I please, your lordship. My lord, this is a review petition filed against the order dated 6/6/2018, there's 18. The matter went up to Supreme Court and the Supreme Court has dismissed the matter at Levine. So on that basis, we have filed this review petition. The order of the Honorable High Court, which we have sought to review, that is page 18.
Yes.
Now, the main grounds on the basis of which we have filed this review petition, that may be seen page 9 of our petition. Page 9, grounds, Lordship may kindly say. The Honorable High Court has not considered the various documents such as voter list of 1966 in its proper perspective, where the name of petitioner's father, Kafur Sheikh, has been listed and 2 copies of cell deeds through which the petitioner's father had purchased
Your
2.
review would not be maintainable.
Hello?
Your review would not be maintainable. The Supreme Court of India order is very clear, 82.
Supreme Court's order, page 82.
Yes, we find no merit in the present SLP. That means merit has been gone into.
No, that
It's not a dismissal in limine.
we find no merit in the present special litigation. The special litigation is accordingly dismissed. But that's not a speaking order.
Not required.
For that matter, Lordship may kindly see, that is Khodai Distilleries. Khodai Distilleries case, that is 2019 for SCC 376. 2019 for SCC 376 para 28. 28 para. In the instant case, since the special petition was dismissed in limine without giving any reasons, the review petition filed by the appellant in the High Court would be maintainable and should have been decided on merits. Order dated 12/11/2008, 2008 SCC online, Karnataka 824 passed by the High Court is accordingly set aside and matter is remanded back to the High Court for deciding the review petition on merits. The civil appeal is disposed.
Stop here. Now. Yes. Just
So-
before, you can see that. Can you read that? Yeah. On to.
But there is another important point.
You've seen that just before paragraph 7.
Paragraph 7. 6, may I read 6?
Yes,
This review petition has been dismissed by the High Court by orders dated 9/9/2011 inter alia with the following observations. For the distilleries case, SCC Online, Karnataka, Paras 2-4. The judgment and decree passed by this court in the above appeal was questioned by the petitioners before the Honorable Supreme Court in special leave petition to appeal civil number so and so. And the petition came to be dismissed on 4/12/2009. According to us, when the judgment and decree passed by this court has been confirmed by the Honorable Supreme Court, question of entertaining any review by us does not arise for consideration. But para 28, my lord. Para 28.
go up. Just go up.
28.
No. Come down. Come down. So come down. Paragraph 3. Yes, paragraph 3. I'm sorry, I gave you the wrong paragraph. Paragraph 3. Respondent one had filed a suit.
Respondent one herein had filed
Last line, this SLP was dismissed by the court on 4/12/2009 with the following order. Now that order is quoted, delay control, special petition is dismissed. That the Supreme Court says in Khode is a non-speaking order. But here in this case, please come to page
82.
page 82. Here it says we find no merit in this present SLP. So that merit has been referred to. So this is a difference between the two. Khode distilleries is not a.
If your lordships are on that point, there is another important point. My sister has been declared as Indian citizen. That lordship may kindly see page 20, page 91-93. 91 kindly see. So that is a good ground in view of Abdul Quddus case.
No, that won't help you.
So this is Kafia Begum. Kafia Begum is my own sister. And the documents which I relied upon before the landed tribunal as well as in High Court are the same.
What is the name of your sister?
Kafia Begum.
Please come to page 52.
Yes.
Is that name disclosed here in the written statement?
Para 5 Kafur Sheikh is the father of Momena Begum.
No, not that. This name, whether she is your sister, is it mentioned in your written statement? No.
Begins.
Can you again come to page after that, after reading that page, can you come to page 95 thereafter?
I'm saying my evidence I am seeing. Evidence part. And because it is not there.
No, then please come to page 95.
Yes.
Your sister also does not reflect your name because
Here, my lord, may kindly see page 97. Page 97. Exhibit F is the voter list certificate copy of 1989 of the office names as Kafia Bibi, wife of Sabur Rahman. Kafia Bibi name
No, your name is Momena.
yeah, my name is Mohammed, yes, and I am.
Momena's name is not taken by your projected sister,
That is not seen here.
not stated.
But for that, my lord, if you also
No,
kindly.
not that. You see, the problem is page 66. Page 66, your opinion came in 16. And your sister got an opinion without referring to that. So it will depend on how Mr. Payang reads it. Had that relationship been disclosed, then we would have considered.
Oh, dear. Father's name, both the women are same. The father's name
You
and
see, we don't have personal knowledge. We depend on the documents to understand.
that is not, his name is, her name is not mentioned here. Now I leave to your losses. Because it is, nothing is there in W or so. About and about, there is one thing, my lord. If your lordship may kindly go through this page 83. 83. Momena Begum, some daughter of Kufur Rahman is there. Kufur Sheikh, Kufur Rahman. Then Munirul Haq, Kufur Rahman, my brother. Then Muhibul Hussain, page 87, my brother. His name is in the NRC, final draft of NRC. And Kafia, 93, Kafia. This Kafia, can you see Kafia, page 91. Page 91, Kafia Bewa, and that is at that time she has become widow. So Kafia Bewa, father of Kufur Sheikh. So NRC discloses that my father and Kafia's father are same person. In that view, so there is a point of consideration.
You have a voters list of 1989 in your case, page 43, 44. Was that exhibited? No.
voter list of 89.
Page 43, 44
Yes, that is, I have
is
seen.
the exhibited document.
Well, I'm not sure. Tribunal order, page 23.
In this review petition, is the family tree available?
Lordship,
In this review petition, is the family tree available?
family tree, that is writ petition, is page 28. You have to see them. Writ petition, page 28. No, separately it is not there. But in between, the
Can you tell, on the basis of your instructions, who is elder? Kafia Bibi was elder to you, or it was Moina Begum who was elder? Out of the two, who is elder?
at present I have no idea, but I shall have to collect information. Seven, 63, 71, those are exhibited. 59. Then in the writ petition, that is not there. Without lordship, of course, that is not mentioned in the WS or evidence, but it is fact. It is fact.
Page 44. Your name is at serial number 4, Momena Begum. She is 28. Correct? Serial number 4. Momena Begum.
Yes.
She is 28. Now come to page 97. This is 1989. What is this? Now 1997.
Yes.
First line. Exhibit F is the certified copy of voters for 1989. Kafia Bibi is aged 30 years. Correct?
Yes.
So she is admittedly elder. But come to page 81. This is your family tree. Here, Kafia is written above Momena. Normally, people go in serial order. It may not always be correct, but this gives a change in seriatim.
But both the sisters' names are there. Both the sisters' names are there, and their father's name is Kafur Sheikh. It is also there. So it may be considered, or if your lordship, in the interest of justice, whether this Kafia and Momena are own sisters or not, a report from police may be called for. Because she has been declared as Indian, there are drafting mistake. They should have disclosed the family tree. Neither in affidavit nor WS they have.
No, they were brilliant. Your lawyers were brilliant at that point of time. That's why we showed you the entire episode. In 2016, you were declared to be a foreigner. And therefore, your statement is withheld by Kakia. She gets opinion in her favor in 2019. After that, now you come and claim benefit of that 2019 opinion.
And review, that is also a ground of review. Review things come, that is also a ground of
It
review.
is suppression of fact. This Kakia suppressed that you are the sister and you were declared to be a foreigner.
But I may take that benefit because,
You may not.
because, this
cannot take advantage of
fact will
the
help my case.
Suppression of material facts would amount
It
to
is
fraud.
not
And even in
suppressed.
collateral proceedings,
It is not suppressed by me, but it was suppressed by
we
Kakia.
understand, but that would amount to a collateral, even in a collateral proceeding. If there is a fraud which comes to the notice of the court, he can still order suo motu revisit of that opinion.
Now, everything is before your lordships. And
Yes, Mr. Payang, what do you say?
Well, my first argument will be, my lord, that this review petition will be not maintainable, as because the Honorable Apex Court in page 82, my lord. On the basis of this, because the Honorable Apex Court has considered the entire case on merit and first the order. So once it is decided on merit, if they want to file a review, they can file in the Apex Court only. We cannot go in the review court. We cannot, my lord, say the Honorable Apex Court has committed an error in merit because it is considered on merit. Had it been, my lord, if the merit was not considered, were not considered, then, my lord, the review could have been maintainable. That is the first point, my lord. Yes. So, because it is clearly stated, the application for exemption from filing official transaction is allowed, translation is allowed. We find no merit in the present special leave petition. The special leave petition is accordingly dismissed. In fact, like other cases, my lord, in order. Yes, peruse the relevant literature. My lord, in other cases, as your lordship has seen, in all the cases where the review petitions are filing here before, in this honorable court, they have withdrawn the leave petitions, leave applications, and, my lord, they're saying that we will file a review there in the High Court, so we may be allowed to file a review. On that basis, those cases are filed. But now this is a special case where the case was considered by the Honorable Apex Court on merit, then dismissed it. If we go for review, my lord, then it will be against the judgment, the very order of the Honorable Apex Court. If they want to file a review, then they have to file a review in the Apex Court of this order only, this order. So my first point will be, my lord, there is no, the review petition is not maintainable at this stage in this format, my lord. Secondly, my lord, Ranit Senior has shown one thing. This, as your lordship has said, there is some fraudulent acts.
No, we won't say fraudulent. That
No,
was
no,
from
no,
Mr. Mahmood,
no, from the part of the, my lord, petitioner, because page 83, what I have seen, my lord, this is referred by the petitioner, that page 84, this NRC document of the petitioner, Momena Begum. How can she enroll his name in the NRC, madam? It cannot be. It cannot be. Because if she declares, if she disclosed before the NRC authority that I have been declared to be foreigner, her name should not have been included in this list. But her name is included in this list. That means she has not disclosed those facts.
Which page?
Page 84, madam. 83, 84. Now they are saying that my name is there in the NRC. So this is settled position of Supreme Court has said, once a person has been declared to be foreigner, or if any case is pending against him, his name cannot included in the NRC. Now, how did she included her name in the NRC?
That is for your home department.
Yes, no, my lord, that is my point also. I'll see. We will have to see it But my lord, this is another aspect where my lord, there are provisions where she has to disclose in the format that if there is any case pending against him or her, she has not disclosed that fact also. For that reason only her name is included. Now it is come to our notice. We'll take action as per the law, my lord. That is definitely we'll take action as per the law. But this cannot be. She has not disclosed. That's why her name is included in this.
No, who will disclose?
That is
The person who is agreed by the order will never disclose.
yes, no, my lord. The point is that bona fideness, my lord.
State has to be vigilant.
Yes, no, that is our part, my lord. Definitely we will see it, my lord. But it is bona fideness of the petitioner.
No. You see, if you would have seen this. This is a review petition of 22.
Yes, no.
Had you seen it, that would have been recommended 4 years back.
Yes, my lord.
Well,
Then, my lord, the
Reply.
another aspect, my lord, those are not valid, but I just like to point out this page 84 documents and the his praying that my lord Kafia has been declared to be Indian, so she may be given the benefit of Kafia. And as your lordship has already seen, neither need the evidence, nor need evidence she has disclosed that she has any sister in the name of Kafia. Similarly, Kafia has not disclosed anything about the Momina. Now, for the time being, my lord, if your lordship may kindly see page 84, if this is the person, my lord, this may be the reason why her name is included in the NRC also. The father name is shown to be Kafur Rahman, madam. Here, in page 84. There in Kafia, if your lordship may kindly see the NRC documents.
Page number?
Page number no, his brother's name has been shown, my lord. That page 88, my lord. They are saying that here it is Kafur Ali, my lord. The father is Mohibul Hussain. It is Kafur Ali. Kafur Ali.
those are common things, my
No,
lord.
no.
Kafur Sheikh, Kafur Ali.
My lord, these are matter of records, my lord. These are matter of records. If even in the computer system, if I change my name, in place of I write E, that will be included in the, my lord. That will be a separate person. Kafia, your lordship will find it page 92.
No, but you see, we are not aware of this system. You'll have to show us this. You see, page 84 and page 88. This is a printout of which date we are don't.
No, I'm not. Yes, my lord. I have not seen it. I have not, my lord, checked it whether it is correct or not. But
You can
Prima
ask the authorities to at least tell you, because that would be very relevant as to the printout is of which period.
yes. No, another, my
And
lord, just
From the website, you get out some other printout of any other person as to how this printout is actually available in the website.
accessible to those persons. That aspect is also to be seen. No, one thing, my lord.
We don't know.
Yes. That is another aspect, my lord. Just I wanted to point out because 84, if we compare 84 and page 92, the father's name, my lord. Page 84 and 92. 84, it is Kafur Rahman, Momina Begum, father relationship, father name, Kafur Rahman. But in 92, it is Kafia Begum, Dewa, name of father, Kafur Sheikh.
Address?
The address can be of the same. We are not on that. Even while computerizing my name, inputting computer, if some input is given in the computer system, my lord, if I change my surname, it will be a definitely different person. It will be definitely accepted.
My lord, I am giving two small reply.
So my point is, my lord, even these documents are definitely, these are, my lord, another aspect, as your lordship has given in numbers of judgments. These documents are not yet, my lord, final documents. These are not yet, my lord, the NRC is not yet finalized. So even though these are annexed here, this cannot be considered as a piece of evidence. However, even though we accept for the time being, names are different, and this person whose name can be included in the.
Just get me out of this.
Yes.
Get me out of
Well,
this.
let's kindly say page 99, only one point, page 99. Learned counsel for the petitioner, it is Supreme Court's order, madam. He has filed an additional affidavit stating that the names of the close relations of the petitioner have been included in the final draft NRC list. Learned counsel for the petitioner further submits that petitioner has filed a claim for
So
inclusion.
these are interim orders. After that, the Supreme Court has already given the judgment.
Yeah.
And
On this
some
point.
value has been given, some value to another draft NRC final.
No,
draft,
that has already been decided. What is the citation, Mr. Ryan?
Yes, I'll provide.
INRC?
Yes,
Just give it, we'll have to rise because my
Yes, yes.
esteemed brother has another bench.
yes, I'll
Pass
provide.
orders in chambers.
Yes.
For the regarding anomalies in names, but these are common, Lordship is aware about this.
I appreciate that, but the problem is that if there is no connectivity,
Page
take into
99.
consideration your submission.
Yes, page 99, last part it is said, my lord, but the same unlikely to be considered in view of the declaration by the High Court that the petitioner is a foreigner. Page 99,
Oh, yes.
the last part it is said,
Yes,
but the
that
same is
why-
unlikely to be considered in view of the declaration by the High Court that the petitioner is a foreigner.
Yes.
So it cannot be
No,
considered.
no, thereafter, kindly see read, then order was stayed.
No, that is different case.
That is
Different case, okay, different case, that is different case.
I'll provide the judgment of the Honorable Apex Court, my lord, where it is said, my lord, the
We'll take into consideration the submissions of Mr. Mahmood. But we'll have to rise my esteemed
Yes.
brother as a bench.